Joining us today is Cathy Creighton, my friend from Buffalo, who is director of the Buffalo Co-Lab, which is an extension of Cornell University's ILR school. Cathy is also a graduate of the ILR school and was a labor attorney for 27 years representing labor unions and workers. Cathy, once again, so excited to have you help us untangle this thorny topic.
Oh, thank you, Chris. Thanks for having me.
Yeah, it's awesome to have you. Viewers, thank you for joining us. I just want a couple notes, give you a couple notes here real quick. We're going to be sharing several URLs throughout the conversation. We will also share them at the end here. And I also want to note that this is going to be a podcast, right? So in a couple weeks, this will also publish as a podcast. If you haven't checked out Cornell Keynotes podcast, we'll drop a QR code or a link here for you so you can check some of our stuff out. Okay, Cathy. So in a lot of workplaces these days, employees are encouraged to bring their whole selves to work. And this means, the whole self, personal convictions, our political selves, things that we advocate for. Is this a good thing or a bad thing in your estimation?
All right. So this is an educational broadcast, so we have to provide education to the public.
Yep.
But I first want, before we provide that education, I want to give a personal opinion that I do think that since we spend so much of our life at work, it's important for us and for a thriving democratic society to be able to talk about issues in the workplace. And for employees to be able to feel like they should be able to tell the public or maybe a journalist that there are bad things happening in their workplace, like it's dangerous here, or they're stealing money here, or those kinds of things. So free speech it's a tricky issue because there's what's moral and right, and then there's also what's legal. And as a lawyer, the one thing you know is that what's moral isn't necessarily legal. So they're two different things. So this is a very interesting question, and it's really timely because employees, as you said, and students and all sorts of people are bringing their full selves to work. But in the US, there's this myth that employees and employers stand on an equal legal footing, and they certainly do not. So in this country, in every state except Montana and a few small municipalities, it's basically the law is that employees are employed at the will of their employer.
Mm-hmm.
So
That's what we call at will employment.
Yeah. And people
Yep.
say, oh, at will employment. I know what that means, but
Yeah.
they don't, because
Yeah.
over and over they say, well, that's not fair. But employment at will means you can be fired for a good reason or a bad reason or no reason at all. So if we just sit with that for a minute and use that as our baseline as we talk for the next while, Chris, the baseline is you're employed at the will of your employer. Good reason, bad reason, or no reason, you can be thrown out the door. And so this long-winded answer to your question, is this a good or a bad thing, is that you should know what your legal rights are before you start protesting at work. And you should know what your free speech rights are before you start protesting at work. And I think that most Americans will find that they have less protections than they think they have.
So what is the law generally about employees using free speech in the workplace? What are we dealing with? I'm thinking about the Constitution. I'm thinking about some of the laws that guide free speech. Does this apply in the workplace?
Okay, it's great to bring up the First Amendment. So the First Amendment says Congress shall make no law which abridges the freedom of speech. So that's really what it says. It doesn't say that you Joe Schmo American, you can say anything, whatever the hell you want to say. It doesn't say that at all. So the First Amendment really doesn't apply too much in the workplace. Let's talk about public sector employees. So public sector employees are government workers, and they do have some constitutional rights in the workplace, unlike private sector workers, which we'll talk about in a little bit. But in 2006, the Supreme Court, in a 5-4 decision in a case known as Garcetti, found that speech on the job for public sector employees is not protected by the First Amendment. So you want me to give you some facts in that case, Chris?
Yeah, please.
Okay. It's pretty interesting. So there was an assistant district attorney. He thought that they were prosecuting someone improperly, and he wrote a memo to that effect, saying that hey, Mr. DA, the case should be withdrawn or dismissed. His boss disagreed with him and continued with the prosecution. And then the defense attorney actually called him as a witness at the trial, and he was forced to testify. He was subpoenaed. So after that testimony, he was retaliated against. He was, in his claim is that he was retaliated against. He was disciplined, he was demoted, and other sorts of things. So there was he brought a claim that his free speech was violated because I'm allowed to say what I want to say. I was forced to say it. I was brought to court to say it. And you're violating my free speech rights under the First Amendment because I'm a public sector employee. So what do you think, Chris? Like, what's your impression of that? Should he be retaliated against for doing that? I mean, what's your initial inclination?
My initial inclination is, well, I mean, this is a public sector kind of thing, right? So should he be retaliated against? No, I don't think so. I mean, the question is like, is this a classic protest speech kind of thing? Would this classify in this case to be like related to a whistleblower type protection kind of? I don't know. That's where my head goes. What do you think?
Right. I think that most people would agree. And I'm curious if we had audience participation, a raise of hands who would think that an assistant DA should be able to say, hey, like, we're prosecuting this guy improperly. And if I'm called to testify, what the hell else am I supposed to do? I'm subpoenaed. I can't say no. But the Supreme Court said that even if all that was true, that the First Amendment does not prevent employees from being disciplined for speech and expressions they make in their professional duties. So if you're on the job working, like this assistant DA was, then you're not a citizen. And because you're not a citizen, the Constitution doesn't apply to you. So in that case, they said you didn't go through any further steps to see if there was a matter of public concern or a balancing of interests or anything else. That's it. You're on the job. You're not a citizen. The Constitution does not apply to you, and you're out the door.
And there was some takeaways as it relates to the Garcetti. I mean, what did we had talked about the three-part test kind of thing, right? So tell us more about the outcome of that one.
Okay, so what the Supreme Court did was it set down a three-part test and said, did the speech happen at work? And if the speech happens at work and you're working, then you don't have any constitutional protections and your case is dismissed.
Okay.
If it didn't happen at work and you were talking as a citizen, like you're now a DA and you're giving a speech outside the courthouse, or you're giving a speech to the Bar Association and you're not at work, now what happens? So then the next step would be, does it address a matter of public concern? And then if you prove that it's a matter of public concern, which is not an easy task, it has to be kind of a big thing for public concern. Yeah. Then is it disrupting the employer's operations as compared to your individual benefit to you to say what's going on? But we didn't get to that full test in Garcetti because he was at work. And I think today we're talking about what happens, your speech at work and then off the job too. So if your speech, this is what we should take away. Yeah. If you're a government worker and you're speaking on the job, your speech is not protected by the Constitution.
So Garcetti's a public forum speech thing. What about workers in the private sector, which I'm just kind of guessing most of our audience will be? Talk about any opportunity for free speech there, right? So what if that is a matter of public concern? Does that figure into the calculus here?
No. Mm-mm. If you are if you're a private sector employee, that means you work for a corporation or a not-for-profit. That's almost everybody in the United States. If you work in the private sector, you do not have any constitutional protections on the job, period. End of story. You don't have free speech rights at all with regard to your employer, period. End of story. It's very simple. So you don't have that. You never bring the Constitution with you to work. You can't put it in your back pocket and bring it to work. It doesn't exist.
I think you and I had arrived at this topic thinking about a larger political polarity in the country, right? and we're going to get into this a little bit because there's several instances we're going to cite here. Does this make free speech at work kind of a bigger issue? Right, there's a lot going on. We can name any of the issues of the day. What about political
Um,
polarity? What's happening here?
well, I think there's a lot of, we've been talking about this now it's not a recent phenomenon. It doesn't feel so recent. It feels like it's been ongoing a long time. We have a lot of polarity in our society and a lot of people fighting each other, people with very strong and different opinions on how society should be formed and operate. And so workers are, and especially young workers, feel like they want to protest in their workplace. They want to have some workplace democracy. And I think they hear about unionization efforts like with Starbucks and maybe Alphabet, and they might be conflating their rights as unionize with their other rights of free speech. So let's take a non-union setting like the Google workers. This happened just a couple months ago where Google workers formed a group called No Tech for Apartheid. They were working on this Project Nimbus, which is a Google and Amazon project. It's a billion-dollar contract, and it's for the Israeli government, and it's being used for technology for the military. And so the workers didn't like that they were working on that project because they felt like it was being used in the war in Gaza. And so they formed a group and they protested that by doing a sit-in at work, and 50 employees were fired. So the question is do they have free speech rights? Like, let's just start with that. Do they have the right to protest at work? Which is really what the substance of this discussion is. Is it legal to fire those 50 workers? And yeah, the first question we look at is like, let's look at the Constitution. Do they have any constitutional? Now, I'm going to ask you this, Chris.
Yeah.
Private sector employees, do they have free speech rights in their workplace?
Did you say public?
Private?
Private? No. You keep saying
No.
that, right?
Yeah. I'm going to say it over and over and over.
Good.
Okay. So private sector employees don't have any constitutional free speech rights in their workplace. So now we're left with these 50 fired workers who I don't know what rights they thought they had or had not. I haven't talked to them, so I'm not really sure. But when you do a sit-in at work or protest at work, you can be fired. It's perfectly legal under the Constitution. So now we have to look at other laws that might apply in this situation. And it's just a hodgepodge of inconsistent, strange state laws, municipal laws that might address the topic. In this case, with the Google workers, they filed a charge with the National Labor Relations Board, alleging that they were engaged in protected concerted activity. I don't know what's happened to that charge. Last I knew it was being investigated, but they'll have to prove that their objection to the kind of work they were doing, to the Nimbus project, that they didn't like that's basically a protest of their working conditions.
So short of being a unionized work shop, it doesn't sound like they had much recourse, right? Or
Yeah,
pretty flimsy standing.
Yeah, it's like they might have a charge under the National Labor Relations Act, but there's not much else that I can actually think of. I mean, there's employers can't discriminate based on race, creed, color, national origin, disability, those kinds of things, but that's not really what was happening here. What's happening here is that employees don't like the political work that their boss is doing. So they're trying to get the boss to stop taking that kind of work for political reasons. And that's just going to be a tough thing for these employees. In the meantime, they're fired,
Yeah, right.
Yeah.
And trying to change the way a company does business. It's just, that's the thing, right?
Yeah.
Yeah.
So for most employees in America, 90% of the workforce is not in a union. In the private sector, only 6% of employees are unionized. In the public sector, it's 5 times that amount. It's 34%. However, there's not nearly as many private government workers as there are private workers. So a union is kind of out of reach, and that's really because the law makes it very, very difficult to form a union, even though America really supports like at up around 70% of the public and 80 something percent of young workers support the right to form a union in their workplace. So if these workers were unionized, then the employer would have to prove just cause to terminate them. So
There was an interesting development that came out of the Enron scandal, though. How did that play out?
So
Very differently.
This is sort of the hodgepodge of how things go, Chris. So the courts generally don't like to tell employers what to do. Like employers want to be able to get employees to just speak in ways that are not against the employer. It's not in the employer's interest to have employees mouthing off and saying things that aren't consistent with the employer. So employers really don't like it when employees start talking about, hey, we don't like the way things are being run around here, or the business isn't being properly run, or employees' pensions aren't being properly safeguarded, those kinds of things. And how all the stuff that goes on in banks, this mortgage, this subprime mortgage isn't working out, like this is bad. So we want employees to be bringing that to the attention of the public. But the law really doesn't provide a vehicle for that. So we had like the Enron scandal, which was that, that was a big company and sort of melted down. And after that, Congress passed the Dodd-Franks Act, and that said provided employees with whistleblower protections. So that employees who had knowledge of bad acts that were going on, financial bad acts that were going on, could bring that matter to the public's attention and had some whistleblower protections. In New York State, like the whistleblower law is so narrow. So each state has its own law, and in New York, it's really narrow. It has to like create a public health hazard for many people. You have to tell your boss and let them fix it. You have to tell them again. I mean, there's a lot of hurdles you have to jump before you can actually get some protections under the whistleblower statute in New York. So this is what I mean, Chris, about these hodgepodge. So something catastrophic happens, and then Congress passes a law or a state passes a law, and now you have some free speech protections that maybe you didn't have before.
Hey, I've got some cool audience questions come in. One comes in from Elizabeth, who says the NLRB, the National Labor Relations Board, has taken an expansive view of NLRA's protections, asserting that they apply to all non-management employees and that all such employees have Section 7 rights under the NLRA. So union membership isn't necessarily dispositive, right?
That's not an expansive reading. That's what the law has been since it was created in 1935. What it says, Section 7 of the National Labor Relations Act says that employees can't be disciplined for engaging in protected concerted activities. And what that means is it has to be concerted. So it has to be more than one person acting. It has to be a group or two at least of employees acting. And the activity has to kind of relate to working conditions generally. So if I went to you, Chris, and said, I'm working as a truck driver and my brakes aren't working, and you said, get in there and drive the truck anyway. And I said, well, no, I'm not going to. And you said, well, you're fired. Would that be protected concerted activity? No, it wouldn't be, because it was just me acting alone. But if a group of employees went to the boss and said, we don't want to drive our trucks because the brakes are bad, and we got fired, then the NLRB could bring an action that we were fired improperly because we were engaged in protected concerted activity. And so I think maybe what the person's talking about is that Jennifer Abruzzo, who is the current general counsel of the National Labor Relations Board, has done a lot of outreach to the public saying, hey, like, come to us and file your charges if your employer is engaging in violations of the act. So it's more that it's been publicized rather than a change in the law. It really hasn't been a change in the law.
Perfect. Great question, Elizabeth. All right, I want to pivot a little bit. There's an interesting case. You and I were talking about this earlier. A developing case in the news, or it's ongoing. This involves a New York City Wall Street law firm called Sullivan and Cromwell, who effectively were doing job prospect or interviewee screening beforehand to understand if job applicants were engaged in campus protests involving the war in Gaza, right?
Yeah.
So what do you think of that case? Tell us a little bit more, because this is you had some updates to the case, but maybe explain how to think about this one.
Okay, so this isn't just Sullivan and Cromwell, but it involves the general issue involves other firms where other firms revoked offers that were made to associates coming out of law school if they engaged in protests on the campus with regard to the Gaza war. And Sullivan and Cromwell said that they were going to look at applicants. So if I'm at Columbia, I engaged in protests and I'm going to apply to Sullivan and Cromwell, then they're going to look through social media, use AI to see my face and to match it to my application and say, hey, you were in a campus protest. And even though you didn't open your mouth or say anything, you were with people and I disagree with their speech. And so we're not going to offer you a job. And then, I mean, that just scares the bejesus out of me because I don't want someone scouring my or other people's social media looking for my face recognition and then deciding whether I get a job if they like my speech or not. Now, I'm not talking about any position in the war in Gaza or Israel or anything like that. I'm saying that I could be at a protest for climate change. I could be at a protest for pro-life protest. I could be at a pro-choice protest. I could be at any one of those protests, and now the employer is going to hire me based upon my political beliefs that they believe that I have because I'm at the protest. And we saw that many people who were involved in the January 6th protest were terminated by their employers.
Right.
So it just is, I think, something that most people don't realize that an employer can do. So these are public, these are private employers. Sullivan and Cromwell is one of the most storied Wall Street law firms, the whitest white shoe law firm. And they're saying, like, we don't want to bring in students who will make other people uncomfortable in our firm. And so we're not going to offer them a job. But now we know from what we've been talking about for almost half an hour that those applicants don't have a constitutional right to the free speech that they engaged in with regard to applying for a job in the private sector. So I don't see a good cause of action that an applicant who's rejected or a person who has had their offer rescinded can bring. Now, just 2 days ago, there was a New York Times article about a letter that Ralph Nader sent to Sullivan and Cromwell with some other people, high-level government people from previous administrations, saying that this was morally bankrupt to be doing this, and asked them to reconsider this position. So that, again, is a moral issue, and morals and the law are not the same. And Ralph Nader also tried to frame it in terms of it's discriminating against applicants because of national origin, for being Arab.
Sure.
Supporting, Arab people. So that might be a stretch. That just seems like a stretch to me, legally.
Yeah, and thinking about it, just maybe it's worth saying again, Sullivan and Cromwell are aiming to create a workplace that is a hospitable place for all, right? So I mean that's their thing, that's their standing. Are they violating any other specific law? Is there any discriminatory practice here? Like, how does this work? And maybe that was the case that Nader was making.
Yeah, he was just saying maybe it's discrimination against one group of people. But it's really, I don't know if there's legal protection for people who are opposed to genocide. Um, that isn't something that there's a law that says that. There's laws that say you're protected for being discriminated against because of your national origin or your race. But I don't see this neatly falling in one of those categories. And I'm sure that these law firms did their research.
Yeah.
I'm sure they did their research and they're, pretty sure of their position, that they didn't do anything illegal. Now it's just going to be whether there's public pressure enough to push back against what they're doing. Because does seem very Orwellian and sort of scary. To me, I think to most people that would seem scary.
All right.
Or
What about
maybe not? Like there are so many young people now are like, oh yeah, I just assume that everybody's going to go through my social media and say, yeah, I'm taking a look at it, and I know every position you have on every single issue, and I'm cool with that. And maybe because I'm almost 59, I'm less cool with that.
Yeah, right. I get it. So
Mhm.
let's think about let's flip it a little bit. The reverse side of the coin. So what about employers forcing employees to listen to employer speech, right? So we've got an organization, you and I kicked around a couple of ideas like the Ben and Jerry's, or a company that is clearly has a public persona of advocacy for certain causes, right? So
Yeah.
how does this kind of play out from a legal standpoint? What does the National Labor Relations Act have to say about this kind of thing? Bible study during lunch or
Yeah.
what have you. I think we get it.
Okay, well, the National Labor Relations Act deals with union speech, like speech around unionization issues or work issues.
Okay.
So in that case, the law has been for many decades that employers have the right to hold what's called captive audience meetings.
Hmm.
And so a captive audience meeting means that the employer can bring you into a room, essentially involuntarily, and discipline you if you don't come, and direct speech at you that's anti-union, and in those meetings, there's usually a lot of veiled threats, carrots, veiled sticks, carrots and sticks approach.
Yeah.
And you're forced to listen to the speech. And so, and you don't have the right to speak back necessarily, or have somebody come in and give a countervailing opinion. That's just you have to listen to the speech. And that's been the law for decades. Now, Jennifer Abruzzo, we've talked about twice now, she has said that she wants to change that, and she wants the board to reverse that precedent and find that captive audience speeches are not legal. There's plenty of other kinds of speeches, though, too, that don't involve the National Labor Relations Act. So if your employer wants you to sit through political speech, I'm supporting this candidate, I want you to support this candidate, you should support this candidate, and you're not in the government, you're not in the government service, you're a private employee, then the employers can do that unless there's a specific law, like Connecticut has a law that says you shouldn't be forced to listen to political or religious speech. New York has a law, I think it passed this session, I don't know if it's been signed by Governor Hochul, which also has a similar kind of language, that you shouldn't be forced to listen to political or religious speech. But in many, if not most states, your employer can force you to go to Bible study classes as long as they're paying you,
Yeah.
and to listen to their political speech. So it's a funny thing, like this is a really good example of this sort of unequal balance of power in the workplace, where employees really can talk at you and you can't talk back. It's like old-fashioned parenting.
Do you have any feelings on how captive audience the legalities might play out around this? Where do you see the wind blowing in any
Oh,
particular way? Like what kind of headway has Jennifer Abruzzo made?
she's brought she's really used her bully pulpit to sort of advocate for positions at a time when many people in America are supporting the right to unionize. So she has taken full advantage of that. We also have a tight labor market, so employees are in better shape if they get fired, or if an employer threatens you with termination, you're not so scared because you can find another job, as opposed to when unemployment is high. You're way more scared to protest. That's why we've seen strike numbers go up extraordinarily last year. But I don't think she has a snowball's chance in hell of getting it through legally. But what's interesting to me now that I'm almost 59 as opposed to 29 is that you see that campaigns happen over a long period of time. And, in order to make change, you have to change the hearts and minds of the citizens, the people who live in the US. So I think that is part of this idea, is that you shouldn't have to be forced to sit and listen to speech that you disagree with and not be able to object or have a countervailing force, and that you shouldn't have to be disciplined if you say, no, I don't want to sit through that speech. So, but it's unlikely that the courts who are above the NLRB will allow that change. I just don't see it.
So where do you see things trending nationally as it relates to free speech at work? You've got several really cool examples in Supreme Court rulings recently as it relates to this, the football coach example and others.
Yeah, things are really have been turned on their head.
Yeah.
Right is left and left is right. And so we're at this weird point in history where we see the First Amendment being used by very conservative Supreme Court justices in ways that we hadn't seen before. So we saw the Citizens United case. That's a case that said that corporations are entitled to free speech. It's so funny because the DA that we talked about earlier, he doesn't have free speech, but corporate money has free speech.
That's right. Yeah. Yeah.
So that was a free speech ruling. And in 2022, I find this case so interesting. I can't actually bring the name of it to my head. But in 2022, the Supreme Court ruled that a football coach, so I'll give you the facts. So a football coach was going to the 50-yard line after games and kneeling with prayers with his players and with anyone else who wanted to join, and praying. And they were doing Christian prayers. And it was a public school. And so the school said, hey, dude, you can't do that. This is a public school. And that violates the Constitution because we're not supporting one religion over another. Mm-hmm. He refused to stop eventually. He stopped for a short time and then he started again. And he was fired. And so he said, I was fired in violation of my First Amendment rights to free speech. And now, let's go back to Garcetti. Garcetti got fired because he didn't get fired, but he got retaliated against for, in part for testifying in court. He wasn't on the job. He got subpoenaed, right?
Yeah. So
the court found the football coach, and why is it important whether you're on the job? I feel like I'm teaching a law school. Why is it important if you're on the job or not? Because if you're on the job, you're not a citizen. And if you're on the job, you don't have the protection of the Constitution. So he said, I'm not on the job.
It was after practice.
Yeah, it was after the game.
No, after the
Friday
game.
Night game.
Okay.
Immediately after the game. And he said, I'm not on the job. And the Supreme Court said, yeah, he's not on the job. The game is ended. And so we don't have to consider that. And then they said we don't have to say that it's a violation of the Establishment Clause either, which is not really what we're talking about today. That's the religious, the Establishment Clause says that the government shouldn't pick one religion over another, the separation of church and state. So So there was a vigorous dissent in that case, and basically the dissent said, of course he was on the job. It follows all of his, his job duties that go to post-game rituals. And it was like on the field. Of course it was on the job. So then if he was on the job, then the school district had the right to terminate him and not have a claim for First Amendment violations against him. So there we see, you can get cynical and say, well, what would have happened if he was, put out a prayer mat and was, Muslim? What would the court have done? I don't know. Probably something different, in my opinion. It's my opinion.
Yep.
So yeah, we're seeing a real kind of switcheroo in what's happening in the left and the right.
I've got a good question here from viewer Camelia, who asks, what about government restrictions on employers for DEI training and federal appeals court ruling Florida's Stop Woke Act infringes on free speech? Any thoughts on that one?
So, yeah, I mean, I have some opinions on that.
Okay.
So basically, I mean, and I want to say that I'm a labor lawyer. I'm not a constitutional lawyer. So I'm not a constitutional scholar. So I do not have a full grasp on a lot of these questions. But, teachers are being fired for talking about issues that violate these don't say gays. I'm going to use that as shorthand.
Yeah.
Statutes. So they can't say things that make kids uncomfortable or talk about race, theory, et cetera. So this is where it's at this interesting contradiction of what is free speech. So it's free speech for the employer. The Supreme Court said it's free speech for the football coach to pray on the 50-yard line. We'll see what the Supreme Court says about these cases. They haven't gotten there yet. So this is all new and emerging law. Will they be consistent? Or will they simply say, well, the teachers are teaching, so obviously they're on the job and then they don't have First Amendment protections, but they're saying that the law violates the free speech. I mean, I don't know. I don't know how it's all going to wash out.
Okay, that's a tough one. Eveline checks in. This is going back to the Google thing, right? So she asks if those 50 Google employees had instead staged a sit-in in a public San Francisco square, for instance, not at work, could they have still been fired for that kind of action?
Yeah.
Yeah. How? Why?
Because
not at work.
Yeah. Because, all right. Because what law did they violate? Did the employer violate in terminating them? The Constitution doesn't apply to them on the job, and it certainly doesn't apply to them off the job. And so you can be fired for a good reason, a bad reason, or no reason. Number one, that's the default. Number two is they don't have a union, so they are stuck there. They don't have a way to object. Number three, you got to think of a law that protects them. And I mean, I don't know what particular state laws. I'm only licensed in New York. But generally speaking, if you are protesting that your employer does, work that you don't like, you're not legally protected from that speech. It doesn't make it immoral, but yeah, you don't have a constitutional protection.
So to sum up, if I'm going to protest at work, what should I expect to deal with? Just to kind of bring us home here. I think
I mean, forever, and this is not new, but forever, employers have attempted to quash employee speech. They don't, and terminate you for your out of work activities. They don't want you getting in trouble. They don't want you getting a DUI at work. They don't want you getting arrested for domestic violence. It reflects badly on them. They don't want you criticizing them because it reflects badly on them. So the default is that you have less protections than you think in the workplace. You certainly have less constitutional protections than you think, which is in today's world, we're always talking about the Constitution, it seems like. We're talking about the president and the Constitution nonstop. I would love to have a day that goes by that we don't have to talk about the president of the United States, any president of the United States. And then, so you should go into things with your eyes wide open. So if you're going to protest and you say, well, let the chips fall where they may, maybe we'll find an ACLU lawyer or a pro bono lawyer to represent us, or we have money to pay for a lawyer to represent us. We'll go that route. But you have less protections than you think. So don't go into protests with your eyes shut. Go in with your eyes wide open.
Very good. So you've provided some really good context and understanding about how this all works. You've also been generous enough to include some articles that we're going to drop in the chat for our viewers that Buffalo Co-Lab has curated for us. For those who have joined today, make sure you check out Buffalo Co-Lab's website. Tons of resources there. In addition, we've dropped several articles too that have taken place, or rather, events that have unraveled over the last several months. Google, UAW among them. So these are all good. These are further augment what you've learned today with our guest Cathy Creighton. Viewers, thank you so much. Really excellent questions that you've submitted there. Cathy, thank you so much for joining today.
Thanks, Chris. It's always a pleasure.
Lovely to have you. Thanks, everyone. We'll see you soon.
Bye.